I think the first point for Belizeans to take away from what happened today is that the government has been saying repeatedly since we filed this application that the applicants didn't know what they were doing, that they were leapfrogging, they were forum shopping, and that there was no merit to this application. Well, 3 seasoned judges of the highest court in the Caribbean have found that once again, the government should stick to politics and leave law to lawyers. The basis on which the court granted relief to us was that we satisfied them that they ought to exercise their discretion because they saw that there was an arguable case and that relief from the Court of the Caribbean was necessary to protect the interests of the parties. Indeed, as you saw this afternoon, the court of its own motion decided that it was going to restrain the sale of shares of Belize Telemedia. Indeed, the objections by my learned friends for the government, and it was 2 of them, going one after the other, whilst we sat quietly hearing them parry with the judges of the Caribbean Court of Justice. The Caribbean Court of Justice found that the sale of these shares should stop. It is signaling once again that perhaps the court believes that the way in which this is being done is unconstitutional, null and void.
We asked for 3 things: special leave to appeal this matter to the CCJ, that was granted. We asked for an injunction restraining any sale or disposal of the shares, that was granted. We also had in the application relief and injunction to stop the passage of the 9th Amendment bill. You will recall, however, that though the court did not grant it, one of the justices, in particular Mr. Justice Hayton, said words to the effect that it doesn't matter whether you get that injunction or not, because if the act is constitutional, you can come to the court and challenge it. And he gave an example that if Parliament, for instance, attempted to make legal slavery, obviously that's not something that could stand. So he was making the point that even though the government, it is our view that he was making the point that even though the government was attempting to bar the court from inquiring into the constitutionality and validity of the acquisition, that as he saw it, the court would still be able to do that.
However, does not that also make the point for the other side that in fact no one is ever at any point barred from going to the court?
I fail to see why, if that's the position taken by the government, why they sought to write into the Constitution in such clear, ample and absolute terms that the court had an absolute bar against it from inquiring on any grounds whatsoever. What they are hoping for is that they can drag this out sufficiently long so that when such challenges are brought before the Supreme Court that we will not succeed, and they can drag this out for a very long time.